Hi, welcome to KiwaniTalk. We're a public information program put together by the people from the Dearborn Kiwanis Club with help from students and staff at Dearborn High School, my alma mater, our guest alma mater, anybody who's anybody's alma mater, Dearborn High School. Welcome to the longest running cable access show in the entire world. This is KiwaniTalk, if I didn't say that before. And we have a guest who is much older than I am because he graduated from here before I did.
I did.
And but he's also a person that I have interaction with in my career because Jeffrey Pepper, our guest for today, is an attorney and he's also a mediator. Jeff, welcome to the show.
Good to be here. Thank you.
Yeah, you did graduate a long time before I did here from Dearborn High, right?
I did.
Yeah, you left your phone on too, dude. What's up with that?
I never even bring my phone in with me, but let's just turn this thing off. All right. All right. So yes, I did graduate a long time before Gary did, 1 year, and obviously my mind is more advanced.
Yeah.
Yes, exactly.
You grew up in Dearborn?
I did.
Where did you go to school?
So my school history was Lindbergh Elementary School, Adams Junior High, and Dearborn High School.
And then the best university in the entire state.
In the entire nation, and that would be Michigan State University.
Right.
Go Green.
Go White.
And Wayne State University for law school.
Very good. You, what was it that made or drew you to the law as a career?
Well, I had my godfather, Norman McIntyre, was a lawyer, and I was very interested in his practice early on. I would say probably by around the age of 12. I thought that I was wanting to be a lawyer. My parents were enthused about that, and so it kind of proceeded from there. Although, while at Michigan State, I studied communications, and there was a period of time when I thought, no, I kind of like this communications advertising business. I think maybe I'll pass on law school. And but that changed.
And when you got to law school, was it everything you thought it was going to be, or was it different?
It was a challenge. That's for sure. The law school years were my favorite years as far as education is concerned. I was a decent student at Dearborn High, a decent student at Michigan State, but when it came to law school, I just hit it. I was just like a top of my class student.
Well, that's extraordinary.
Not the top, but
that's good.
Yeah.
So, when you finished law school, you started practicing, what kind of law did you do?
General practice. I started with Arthur Allen Smith. Now that's kind of a old Dearborn name, O.L. Smith. Junior high school is named, or middle school is named after Arthur's father.
Okay.
I think he was an attorney general in the state, if I'm not mistaken. So the firm was Smith, Poplar, and Kalis, and I did that for 5 years and then went out on my own and have been ever since.
And as people say, a general practitioner, every once in a while, I started out that way in my practice, but kind of narrow your range down. And what did you kind of narrow down to?
Well, as it were, it was basically a family practice. I would say, the family practice became a larger portion of my practice as the years passed, and at this point in time, having turned my attention to alternative dispute resolution in family matters, it pretty much is my entire practice.
And so you've been practicing law for how many years now?
This would be 43 years this year. 43
years. I don't understand because I was only a year behind you in high school, a year behind you in college, but I'm only up to 37 years. That's because I took time off before I went to law school.
Well, I was going to say, as I've said before, it's because you flunked a lot, but I believe you did actually take time off and enjoy yourself.
Yeah, I traveled around the world and worked overseas too.
Not
so that
bad.
Was a good thing. The practice, the divorce practice, which I do a lot of and you do a lot of, how, if you think it has it all, how's it changed in the last 43 years?
Well, I would say that it has, the law has evolved, certainly. There is certainly a greater emphasis on fathers' rights. Now, I hate to use that as kind of a catch phrase, but certainly when I started practicing, and this is going to sound gender biased, but it was the way it was a matter of women getting custody of the children and dads having parenting time every other weekend and a dinner on Wednesday or something like that. That seemed to be...
Maybe a week in the summertime.
Maybe a week in the summertime. And that's evolved quite a bit. And now there's, I think, a great deal of willingness on the part of judges to consider fathers as a primary custodian, and 50-50 parenting time, equal parenting time, more or less, is probably the norm these days.
Do you think it too? I see a lot more fathers being more involved with their kids than when I started 37 years ago. They want to be part of their kids' life. Not that they didn't want to before, but much more, you know, it wasn't something a guy did was to raise kids back then.
Well, too, I think it's a function of, over these 43 years, there's certainly been more working mothers. And so you have kind of a sharing of both functions, the wage earner function and the child care function. So there's been more sharing of that while parties are married, and therefore it's a natural extension that there be sharing of that if they divorce.
Now, when you have a divorce case, and I know the answer, but there's a range
We'll
of
see if we agree on the
there's
answer.
a range of possibilities of how a settlement's going to work out. And what's the likelihood that someone's going to walk away with all the assets and some walking away with none? And I know the answer.
Well, it depends who their lawyer is. That's not the answer.
No.
The answer is that's not going to happen. We have statutes in place, and we have case law in place. And in Michigan, we're an equitable jurisdiction, meaning that the courts will decide things equitably. But the way that's been basically interpreted by members of the bench and the Court of Appeals is you're going to divide property in rough congruence. And there's definitely a preference that it be 50-50, but if it's close to 50-50, that's the way it's going to be. But nobody's going to walk out with everything and nobody with nothing.
I think when you even get to 60-40, unless there's extraordinary circumstances, that's going to get reversed if there's a decision made on that.
Absolutely, because that would not be roughly congruent. So the point that you may have been making there is that sometimes you can have, if you go to trial, and I'll talk about trial in a second, if you go to trial, the court is bound by the rough congruence rule unless the court finds, generally by conduct of the parties, that there might be a fault factor that would compel a different distribution. And even if there is a fault factor, Court of Appeals has pretty much indicated the maximum that you can go to address that would be a 60-40 split.
And to have fault, the way I tell my clients, unless you have DVD quality video, you know, high-def audio of your spouse in flagrant delicti with other genders, other genders, and maybe extra species thrown involved, you get very hard pressed to get to that 60-40 split.
Well, true, but that kind of behavior, we're talking adulterous behavior, is only one of the factors that comes into play. Frequently we see drunkenness, gambling, drug use,
Domestic violence.
Domestic violence certainly is one of them. So there are a number of bad actor kind of activities that people can engage in to cause a different than 50-50 split.
The problem is that if you go to trial, there's a component there economic-wise that makes it undesirable to go to trial.
Exactly the point that I frequently make in mediation, and that is, all right, if you've got a $100,000 estate and you're going to go to trial and spend the attorney fees to go to trial to try to get a 60-40 division of property, well, you're talking a $10,000 swing, and the attorney fee is likely to be larger than that in order to do it. Now, if you've got a multi-million-dollar estate and you want to make a 60-40 split, well, then maybe there would be some economic incentive to do it. But by and large, I don't think most judges are inclined to easily find fault in a case. I mean, sure, if somebody's punching their spouse and just being horrible in that regard, that's one thing. But early on, when we had no-fault divorce come into play, when the legislature passed that statute, there was uncertainty in the court rooms about what does that mean, and ultimately required a decision by the Supreme Court to say, well, yeah, it's no fault, but that only means that you don't have to prove anything to get the divorce. You just have to show that there's been a breakdown in the marriage relationship. And in the olden days before there was no fault, they had actually had a side industry of people who would break into the motel room and take a picture of two people in bed, something to show some actual fault. But no fault just said you don't have to prove that to get a divorce. But the Supreme Court did say that, yes, when it comes to dividing up property, fault can be a factor. And the point that I was going to make was the first case did involve marital infidelity. And it was a 4-3 decision from the Supreme Court saying, yes, this is a factor that the courts can consider. But there was a dissenting opinion that said, well, like, who are we to say that marital infidelity was the fault factor in this marriage? We don't know what went on beforehand. And in fact, infidelity is usually the last act of a marriage that's already in trouble. So we think it's not right to do that.
All of those things, the change in the law away from having to find fault, because you would have to say some pretty horrible things about a person that you once loved, that you once thought enough of to have children with, that you once thought that you would spend your entire life with, and that going forward makes it difficult to be able to co-parent kids.
Oh, absolutely, and that trial process is sometimes the divorce process itself makes worse than just the divorce itself. That's a sad enough event. We're getting divorced, and getting to that conclusion is probably the hardest part. But certainly people who choose to use the divorce process as a scorched earth policy will succeed in doing that, financially, emotionally, and I can just say that the trial, we talk about, trials. One of our colleagues, Carlo Martina, did a study of the cases that had been disposed of in Wayne County Circuit Court, meaning divorce or custody disputes that were actually disposed of, 4,615 cases in the family division of the Wayne County Circuit Court. And of those 4,615, only 50 were decided by trial. That's about 99% of the cases get settled without the necessity and the expense of trial. And so if you're one of those unfortunate 1%, buckle up.
Maybe I'm getting older and more curmudgeonly, but I think I've skewed that number recently because I had a trial Friday, trial Monday, and a trial yesterday. So.
Well, the one thing that Carlo didn't tell me was who the lawyers were who were involved in those 50 trials. Now, I'll tell you, I'll bet you there were about 10 that were involved in all of them.
I know one of them used to be a teacher here.
Well,
we should remain nameless.
Yes,
anyway.
exactly.
But
exactly.
What we're going to do, we're going to take a little break right now. We're about halfway through the show. We're going to come back and talk. Now we talk about all the bad things about divorces. There's another way, and a much more economical and much more, I'll say, civilized way of getting people to live apart together.
Yes.
And we'll come back with Jeff Pepper right after that. Don't go away.
It's easy to get caught up in the details. The day-to-day grind, numb to the noise, going round and round and round. Deep down, there's something missing, a void inside, a hole to fill, a life lacking. Then, in a minute of clarity, it hits you. The aha moment. You're needed. Kids need you. Kids of all kinds. All these funny, rambunctious, sweet, attention-seeking, vulnerable bundles of energy. They need your love and support. Some have huge life hurdles. Poverty, disease, hunger. And they're reaching out for you. Around the corner, around the world. You are a Kiwanian at heart, a role model, a guide, a builder of dreams. Together, we are Kiwanis, passionate and strong, ready to move mountains or grains of sand. Imagine every child reaching their potential. The power to help is in you. It's not about us. It's about them. Do you hear the call? Kids need Kiwanis. Kiwanis needs you.
Hi, welcome back to KiwaniTalk. I'm your host, Gary Gardner, on this episode where we're talking about divorces, which is a sad topic, but there's a way that can make the process a little less uncivilized. And Jeff Pepper is one of the prime mediators in Wayne County. I know that the judges that I deal with on a regular basis, when I mention a potential mediator, Mr. Pepper, they all say absolutely, and he's a good person to have.
Well, that's nice to hear.
So, what is this mediation thing, Jeff?
All right, so mediation is part of what's known as alternative dispute resolution. And what that means is that the parties have an opportunity to speak with a mediator. It usually involves counsel and their parties. And we talk about it. And we come to in a comfortable atmosphere. I mean, look, this is the way I am dressing for mediation, usually without the coat. I want people to be comfortable. They're in my office. And this is the way all mediators do it. And it's a discussion. And what mediation does is empower people to make their own decisions, affecting their own future rather than leaving it to a stranger, which the judge is, and just a more ameliorative approach to a very difficult problem situation.
And sometimes when there's unequal bargaining powers, people worry about how am I going to deal with my husband or my wife across the table from me. That's not the way it works.
So there are a couple of models for mediation. One of them is that all parties and counsel sit in the same room, but by far the desired approach is that one lawyer and client sit in one room and other lawyer and the other client in another room, and the mediator goes back and forth. This promotes free expression rather than all the parties sitting in the same room. People can feel comfortable telling the mediator some things that maybe they don't want the other side to know. Not that they're keeping a secret, but personal feelings about things. And we mediators are bound by some rules of confidentiality. And if there's something that a party tells me in a room that they wish not to be shared in the other room, of course, we'll absolutely protect that confidence.
So the process then is you meet with one party, you go back and forth, and the attorneys usually present a sort of a summary of what the assets, liabilities, and issues are ahead of time?
Yeah, that's right. We ask for written summaries from the attorneys, and some of the times I get them. Sometimes I don't. Mediation summaries are supposed to apprise me of what the facts are and what the assets are, and is there a child custody dispute here or a parenting time issue. So I have that in advance and I'm prepared to speak with the parties. Mediation summaries, like this mediation that kept me a little bit late in showing up for your show here today, they can be useful tools for a mediator, but they can also be somewhat problematic if somebody is going to use that forum as a matter of attacking the other spouse, and then the other spouse reads it and gets ticked off about this. That didn't happen here today, but what did happen was I think one of the lawyers in writing the summary and asking what should happen in this case had maybe created some unrealistic expectations on the part of her client. And so when we get down to the brass tacks of it, well, no, you're not going to be getting this much spousal support, and no, you're not going to get that. And it created a difficulty for me to get the case settled because somebody came in and was finding all of their hopes dashed. Not all of them, but they just weren't getting what they may have been led to believe that they were going to get.
The old expression, under promise and overperform, is true, but sometimes when you're going into negotiations, you want to aim higher so you can come back to a low spot, and that's a balance that you have to work out.
No, absolutely, that is it is. I expect clients to and lawyers to reach for the moon, but I would hope that lawyers would be telling their clients, well, this is what we're going to ask for, but don't expect that this is what the result is going to be. Basic negotiation. So in addition to going back and forth between these rooms, the mediator's role is to, of course, secure an agreement. But mediators, fortunately, bring some knowledge to the table as well, and we have an idea how judges think about things, particular judges, the bench generally. There are some things that are beyond our control, like here's child support. It's based on income. It's based on overnights. I mean, that's what it's going to be. And but by and large, people do look to the mediator to share their expertise and their years of experience to help them come up with a fair resolution.
Now, you mentioned earlier the cost of a trial, and that although trials are rare, they do happen.
Yes.
Versus the cost of a mediation. And what is a typical mediation session run time-wise?
Well, we try, I'd say time-wise, 4 hours is a good mediation session, and typically we're able to know in those 4 hours whether or not the case is going to settle or whether it's not. You know, mediators don't give up easily, and mediators actually have the authority to say, okay, fine, we're time limited here, but you are coming back because the mediation isn't over until the mediator says it is. So I would say about 80% of my cases, I don't know about other mediators, require only one session to come to a successful resolution, but sometimes people have to come back, like tonight. I was this close to getting that case settled, but I was time limited and still managed to show up late for your show.
That's okay. We'll forgive you this.
All right, thank you.
At the end of I'll say this. People can say things to each other in person and they can get over it. People can say things to family, they get back to the people and they get over it. Friends, they get back. But if you say something in court, with the court reporter taking it down or being transcribed, those same things that people could get over in the past become etched in stone. And so that creates problems in the future for parents. So what about the idea of maybe giving up a little bit that's not going to be important to preserve domestic tranquility and make it easier for your kids going forward as far as their lives?
Critically important. First of all, cases that end up going to trial because parties cannot agree on custody and parenting time, it's never over. Somebody is going to view themselves as the winner, somebody is going to view themselves as the loser, and from that point on, every skinned knee that a child has, or every little mosquito bite the other parent's going to complain about, it will continue. And my usual rationale for people to resolve it themselves is that most people want to have joint legal custody, which means that they will be involved in joint decision making involving major issues affecting the children. And the best place to start is now, not later. And so the best place to start is at mediation. And I want to say, to your point, a trial is sitting on a stand and being cross-examined, and somebody like Gary Gardner coming at me and making me look like a fool, while other people are out there in the courtroom and people are coming in and out and the judge is talking to the clerk. That's what that's all about. It's not the cool smoothness of TV drama. It is somewhat chaotic. You get scheduled to come to court at 8:30 in the morning. Your trial starts at 10:30. You get an hour and a half, then you come back for lunch, and that process takes a while and therefore is very, very expensive, as opposed to coming to mediation or even arbitration in a nice office with big easy chairs. There isn't a record being made. There isn't the public coming in and out. There's some snacks on the table. Here's some coffee. Here's some water. It's a very comfortable, very calm experience, and therefore I think just that atmosphere is fruitful for resolution.
At the end of the session, and if the parties have reached a resolution, you walk out the door with a formal agreement. Talk about how that works.
Correct. So different mediators do it different ways. Some mediators will make a tape recording and of the agreement and get everybody's acknowledgement that that is their agreement. They agree to be bound by it, and later produce a transcript of that tape recording. Some mediators, I understand, burn a disc, and you can give the disc to people as they walk out. I have a written contract. It's a form that addresses many common issues in divorce and parenting time and property and what have you. And so this form is filled out and it's signed at the end, and people walk out with a written contract, which the courts are going to enforce virtually every time.
Because a written contract is binding?
Written contract is binding, absolutely. Now, judges always retain jurisdiction over child-related issues, and theoretically, a judge could say, "Oh, I don't agree with this." That's theoretically. In fact, the statute circumscribes judges' authority in that regard by saying that they must adopt an agreement of the parties unless it is clearly not in the best interest of the children. But as far as property is concerned, judges are not going to get in the way of a property settlement. And nor are they going to get in the way of a custody settlement. If people walk out with custody and all of that to settle in this contract, 99% of the time that's going to be adopted by the court.
We're coming down to our last couple of minutes. You mentioned in passing the word called arbitration. How briefly is that different from a mediation?
So every domestic case where the parties can't come to agreement themselves will be referred to mediation. And again, that's just me acting as a facilitator and hoping the parties and encourage them to agree and settle the case themselves. Arbitration is something that a court cannot order parties to participate in, but the parties can agree to arbitrate the matter, and that would be letting an arbitrator decide the issues that would otherwise be decided by a judge. It's probably more efficient than a trial because you can sit down in one day and probably knock it out, or two, whereas the trial process, as they say, can be, over several days and several months. So it gives you an opportunity to choose your own judge, and that's usually a desirable thing, that both parties can come to an agreement that this person is somebody we would trust to make a fair decision.
There's been changes in the law over the past, and do you have any crystal ball to see where we're going down the road in the next few years?
Well, there has been every year, as far as I know, for about the last 20 years, some legislation afoot to make a presumption that parents should have 50-50 parenting time. This would be the singularly worst bit of legislation that I can think of.
Call it the Full Employment for Domestic Attorneys Act of 2019.
Well, something like that. I would call it the full "we don't care about kids" thing, because you just can't say that in every single case it should be 50-50, because that just isn't always the case. So that is a cookie cutter approach to a very sensitive issue. That would be horrible. I'm thinking too that there's some legislation that is going to try to codify spousal support similar to child support. Many states have that. We don't, but there may be an initiative there as well.
Well, I want to thank you very much for coming on, Jeff. People don't understand that a difficult situation in many respects can be made a lot easier by a trained mediator who is sensitive, who has experience. And I think that you managed to check off all those boxes. Okay,
well, thank you very much. I'm always happy to see Gary in my office. Fine lawyer, advocate, but being an advocate doesn't mean you have to be oppositional in mediation. And Gary is one who certainly tells his clients what they need to hear, not what they want to hear, and that's a very important attribute.
Well, thanks a lot, Jeff, and thank you for watching KiwaniTalk. We'll see you again next time, and if you're getting out this process, remember the name Jeff Pepper. Tell your attorney he's a guide. If he doesn't know who Jeff Pepper is, get a different attorney.
There you go.
Good night. Bye-bye.
All right. Yeah.